Had no prior experience in elections law, is that correct?
Also incorrect. So both things are incorrect.
Who from outside the Civil Rights Division or outside of the Department of Justice gave you advice about that letter?
In terms of that letter, again, anything related to how that letter was formulated is law enforcement privileged.
That just ain't so. No one contributed text to you. No one contributed ideas to you. No entity or person asked you to do this.
Again, these kinds of things would be part of privilege.
Could you, are you aware that the FBI executed a search warrant with respect to the Fulton County election records and seized a considerable number of records?
I'm aware from the news, yes.
Did you have any contact with any person within the Department of Justice or the FBI relevant to that search warrant application or that search?
No, during that time period, if I'm remembering correctly, I was at OMB.
No one reached out to you?
No one reached out to me.
How about the witnesses that were in the search warrant application? Did any of them have any contact with you related to that search warrant application or that search?
I don't know who the witnesses are, but to my knowledge, no.
Let's go back to your Georgia letter when you were in the Department of Justice. As I understand it, you had been in the Environment and Natural Resources Division, which has no authority over elections. You had been acting chief of the Civil Division as people cleared out at the end of the Trump administration, again with no role in elections.
Incorrect.
And as best I can tell, you had no prior experience in elections law. Is that correct?
Also incorrect. So both things are incorrect. I ran the two divisions, the Environment Division and the Civil Division, total of 1,400 lawyers simultaneously. And the Civil Division did have several election cases. There are two major sets of them. One were you directly involved in any of those cases? Yes. There's one in particular I will tell you about, which
well, that's okay. I'm asking the questions here, so let me continue. When you wrote that letter, who in the Civil Division did you contact with respect to its contents?
That is something that would be law enforcement privileged inside the Justice Department.
No, it's not.
It absolutely is, Senator. What lawyers I consulted and what they said and what I said to them, all of that is something
No, what lawyers you consulted, maybe what you said, but certainly what lawyers you consulted. I'm entitled to know if you bothered to consult a single lawyer in the Civil Rights Division before you did that. But I'll turn to a different question. Who from outside the Civil Rights Division or outside of the Department of Justice gave you advice about that letter?
In terms of that letter, again, anything related to how that letter was formulated is law enforcement privileged.
That just ain't so. And let me ask that the record include the Board of Professional Responsibility opinions with respect to throwing out Mr. Clark's claims, false claims of privilege. So let's just say that somebody from outside the department put you up to writing that letter and told you what they wanted in it. What privilege would that require?
Well, there, Senator, hopefully I can help you by assuring you that there was no one from outside the department who put me up to writing a letter. I'm quite capable of writing a letter, thinking about it, and making my own legal decisions.
No one contributed text to you? No one contributed ideas to you? No entity or person asked you to do this?
Again, these kinds of things would be part of privilege.
No, they wouldn't.
You're
just wrong about that.
Well, you can say that, Senator, but I disagree with you. And
I know, but you've asserted privileges before, and you've been wrong. You assert privilege willy-nilly with no real basis for it. So, by the way, it's not even conceded that those privileges matter in Congress. In fact, Chairman Grassley has repeatedly said that there are a number of privileges, and I think many of us agree with him, that simply don't pertain to congressional investigations because of the separation of powers. So what we're asking about here is whether you were put up to this by outside entities, whether those outside entities helped get you the meeting in the Oval Office with Representative Perry, who was behind that, and who was behind finding you a dark money-funded landing pad once the Department of Justice tenure was over and you were picked up by a dark money-funded advocacy group. Those are legitimate questions. I intend to pursue them.
What you just watched wasn't the end of this story. The legal battles surrounding Jeffrey Clark continued immediately after this April 21st, 2026 hearing. During the same Senate Judiciary Committee hearing, Ranking Member Dick Durbin reminded the committee that Clark had already appealed the D.C. Board on Professional Responsibility's recommendation that he be disbarred over his actions following the 2020 presidential election. Clark's related legal proceedings also remained active after the hearing. His appeal and other litigation continued moving through the courts, demonstrating that the issues discussed before Congress were far from resolved. Then, on May 13, 2026, the Department of Justice took the extraordinary step of filing a federal lawsuit against the D.C. Bar's disciplinary authorities, arguing that the disciplinary proceedings against Clark improperly targeted legal advice provided during his service at the Justice Department. The lawsuit sought to halt the D.C. Bar's case against Clark, ensuring that the controversy remained active well after this hearing concluded. Those developments explain why Senator Sheldon Whitehouse pressed Jeffrey Clark so aggressively during this exchange. Whitehouse focused on Clark's role in drafting the controversial Georgia letter during the final weeks of the Trump administration and repeatedly questioned whether anyone outside the Department of Justice helped shape that document or encouraged him to write it. The hearing began with questions about the FBI search of Fulton County election records before quickly shifting to Clark's actions inside the Justice Department after the 2020 election. Whitehouse argued that Clark had little meaningful experience handling election matters and repeatedly demanded to know which Justice Department lawyers, or outside individuals, had been consulted before the Georgia letter was prepared. Clark rejected those characterizations. He testified that he had supervised both the Environment and Natural Resources Division and the Civil Division, explaining that the Civil Division handled election-related litigation and that he personally participated in some of those matters. However, when asked who contributed to the Georgia letter or advised him during its preparation, Clark repeatedly declined to answer, arguing that those discussions were protected by law enforcement privilege and confidential legal deliberation. That disagreement became the central conflict of the hearing. Whitehouse insisted that Clark was improperly invoking privilege to avoid legitimate congressional oversight. Clark maintained that revealing internal legal discussions would violate long-established protections governing confidential Justice Department communications. Neither side accepted the other's legal interpretation, and the exchange became increasingly confrontational. It is important to distinguish between accusations made during a congressional hearing and established legal findings. Senator Whitehouse strongly challenged Clark's assertions of privilege, while Clark consistently defended them. The hearing itself did not determine whether Clark committed a crime, violated ethics rules, or improperly asserted privilege. Those issues remain matters for courts, disciplinary proceedings, and other legal processes rather than congressional hearings alone. The broader significance of this exchange extends beyond one witness. It reflects an ongoing constitutional debate over the balance between congressional oversight and executive confidentiality. Members of Congress argue they need complete information to perform meaningful oversight, while executive branch officials often argue that confidential legal advice must remain protected so government lawyers can provide candid counsel without fear of later disclosure. Ultimately, this hearing was about accountability, transparency, and the limits of executive privilege. Senator Whitehouse argued that Congress cannot effectively investigate matters of public concern if witnesses broadly refuse to answer questions by invoking privilege. Clark maintained that protecting confidential legal deliberations is essential to preserving the Justice Department's independence. The verified developments that followed, including Clark's continuing disciplinary appeal and the Justice Department's May 13th lawsuit seeking to block the D.C. Bar's disciplinary case, demonstrate that the legal disputes discussed during this hearing continued well beyond the hearing itself and remain part of a broader national debate over executive authority, professional responsibility, and election-related investigations.